Okay, hi. My name is Jonelle Humphrey, and I'm a PhD candidate at McMaster University. So my thesis explores Canada's experimentation with various forms of governance and regulatory techniques to combat modern slavery in global supply chains. So this presentation is going to focus on one of those governance techniques, and that is modern slavery legislation. So just for a little bit of background, the methodology I use in my thesis to assess the impact of these laws and whether they are actually benefiting supply chain workers included doctrinal legal research, which means that I assess the wording of the statutory provisions, their mode of operation, and the potential impact that they would have through legal interpretation. I also conducted interviews with stakeholders, including parliamentarians, civil society organizations, and business associations regarding their opinions. Sorry, as to whether these laws actually improve labor standards for supply chain workers. So workers at the bottom of the supply chain bear the risk of any disruptions in the supply chain. And this was unfortunately highlighted during the COVID-19 pandemic, where supply chain workers suffered increased conditions of forced labor. Policymakers are promoting modern slavery legislation as a way to improve labor standards, but these laws currently do not achieve this goal. So as this presentation will show, more focus needs to be on increasing worker voice and participation in the protection of their own rights. Okay, so modern slavery and forced labor in supply chains. Modern slavery is an umbrella term. It covers a range of practices, including forced labor. So the International Labor Organization defines forced labor as all work or service which is extracted from any person under the menace of penalty for which said person has not offered himself voluntarily. So forced labor in supply chains was already an issue before the pandemic. However, the pandemic considerably worsened labor conditions for lower tier supply chain workers. So an example would be the medical glove industry. So the pandemic increased the demand for medical gloves and just PPE in general, personal protective equipment. So over 1,000 Malaysian medical glove factory workers reported in 2020 an increase in 4 of the ILO's forced labor indicators: excessive overtime, abusive working and living conditions, restrictions on movement and isolation linked to lockdowns introduced to protect public health. Another example of workers who were affected was workers in the garment sector. So the pandemic decreased demand in the garment sector because in early 2020, all clothing stores were basically physically shut, right? The physical locations. And the Worker Rights Consortium and the Center for Global Workers' Rights, they did a report called, I think it's Unreported Billions or something, but it was a good report. And basically in the first 3 months of the pandemic, brands in the USA and Europe canceled and withheld payments of $16.2 billion in orders. And these were orders that were placed months before the pandemic and were almost near finished or finished already. So this forced suppliers to reduce and stop factory operations, leading to the laying off of millions of factory workers, and in most cases without pay or severance. So the report stated this led to approximately $1.6 billion in lost wages for factory workers. So the pandemic therefore highlighted that the workers at the bottom of the chain bear the risk of supply chain disruptions, and they therefore require greater protection. So pre-pandemic, home countries of multinational corporations were implementing legislation meant to combat forced labor in supply chains, and there are 3 models: transparency legislation, mandatory human rights due diligence legislation, and mandatory human rights due diligence with civil liability. The first model is transparency legislation. It requires companies to produce an annual statement outlining the steps they have taken to ensure that modern slavery is not present in their supply chains. So the desired effect of these laws is that investors and consumers will use their collective investment and purchasing power to boycott and shame businesses failing to sufficiently disclose their efforts to ensure that they have slavery-free supply chains. So this model is very dependent on the threat of reputational damage. So California, the UK, Australia, and recently Canada enacted this model. And then mandatory human rights due diligence legislation. It requires companies to exercise due diligence in their supply chains and not just simply report. So an example is the French law, the French Corporate Duty of Vigilance law. It mandates companies to implement and report annually on a vigilance plan. And this plan, they have to identify, analyze, and rank supply chain risk, regularly assess suppliers and subcontractors' actions for human rights violations, develop reporting mechanisms for workers in conjunction with trade unions, and monitor the efficiency of the mechanisms put in place. So the sanctions for this model range from fines to public exclusion from public contracts for companies that fail to comply with the law. And a lot of European countries, Germany, Norway, Switzerland, have enacted this model. And the third is mandatory human rights due diligence with civil liability. It just goes a step further to impose liability for negligence on companies. And this model establishes a legal obligation to adhere to a standard of reasonable care when carrying out acts which could foreseeably result in harm to human rights or the environment. So any victims can bring an action, a tort action, to claim remedy in the home state of the company. And again, the French law is an example, and also recently the European Union Corporate Sustainability Due Diligence Directive, which was passed in May 2024. So post-pandemic promotion of modern slavery legislation. The support among policymakers for modern slavery legislation after the pandemic still very strong. The Modern Slavery and Human Rights Policy and Evidence Center recommended that government departments and businesses in the UK take stock of the vulnerabilities highlighted and exacerbated by the pandemic and utilize the UK law, the reporting mechanism in that law, to outline any new steps in their due diligence to mitigate or prevent modern slavery impacts of any similar crisis. The sponsor of Canada's Fighting Against Forced Labor and Child Labor in Supply Chains Act 2023, Senator Julie Maville-Deschênes, she successfully used the increase in forced labor during the pandemic to demonstrate why legislation was needed in Canada. So these laws, though, are unlikely to mitigate or prevent modern slavery impacts. In terms of transparency laws, why these laws don't improve labor standards, transparency laws, they rely way too much on consumer pressure and reputational damage to alter company behavior. So one of the interviewees that I was talking to, he's a lawyer, he said no one's going to sit on Friday night and read modern slavery reports filed with Parliament to see which companies they should avoid purchasing from for using forced labor, which is true. And so asymmetry in information, companies rarely report information that doesn't put them in a positive light, such as forced labor in their supply chains. So the consumer, therefore, doesn't really have the full picture to make an informed decision about which companies to boycott. And companies rarely look beyond the first tier of their supply chain because they usually contract directly with just the supplier in the first tier. However, modern slavery typically occurs lower down the chain. And mandatory human rights due diligence laws, it relies on social auditing, although it's supposed to be a process of ongoing consultation with worker representative organizations to develop and implement due diligence procedures, but they don't do that. And the reports of third parties or in-house company auditors are often unreliable because these auditors have an interest in maintaining business with the brands. Factory owners and suppliers, they conceal evidence of forced labor from auditors, for example, of excessive overtime. They mess with timesheets and stuff. They intimidate workers into concealing evidence as well. And another issue with this model is that not enough focus is placed on remediation in the due diligence process. So for example, having provisions in place for severance pay in the event of job loss during an event like the pandemic. And this model with civil liability. So although it's great that, there is a way to have access to justice by means of bringing a claim in the home state of the country, in the home state of the multinational corporation. Transnational litigation is a long, slow process, an average of 10 years. And this is because of, overseas claimants, language barriers, gathering evidence from abroad, funding. Also, the burden of proof is on the claimant. So they have to prove that there's a causal link between the company's negligence and the damage suffered, which is increasingly difficult the more remote the damage is along the chain. Side note, NGO Sherpa in France, they're actually advocating, and they have been from the beginning, for a reverse burden of proof, so that the companies have that burden and not the claimants. So the defense of having conducted due diligence could possibly trigger the safe harbor doctrine, which excludes a company from liability for harm caused regardless of the quality of its due diligence. And generally, with all these models, these laws just do not really remove or challenge the legal doctrines of privity of contract, which is a lack of direct contract with suppliers below the first tier of the chain, and separate legal personality, which deems parent companies separate from its overseas subsidiaries, which allow MNCs multinational corporations, to distance themselves from liability for harm caused in its supply chains. So these laws just make companies accept some of the responsibility for minimizing the risk of harm in their supply chains without imposing direct liability. So they don't get rid of anything that makes supply chains, the whole legal framework. They just put another layer over it. So lessons from worker-driven social responsibility. Modern slavery laws, they don't challenge any of the legal protections that multinational corporations have, and they also fail to give workers a voice in the protection of their own rights. So lessons can be learned from this emerging paradigm of worker-driven social responsibility, which is designed to directly empower workers and hold MNCs accountable. So the model includes legally binding agreements between companies and worker organizations, where the company commits to providing financial support to suppliers to assist them in meeting the required labor standards. Companies must also cease doing business with suppliers who do not adhere to the agreement. Companies which fail to comply with the agreement are subject to enforcement via arbitration, for example, and workers are given a voice in the protection of their own rights, which includes negotiating terms of the agreement, being educated about their rights, and reporting violations of their rights. So an example of such an agreement is the Bangladesh Accord on Fire and Building Safety, which seeks to improve the safety of garment factories for workers. So global labor unions like industrial and all these worker organizations like Worker Rights Consortium, Clean Clothes Campaign, they were all involved in negotiating the terms of the accord, and also the monitoring of it after, which was very much worker driven. They make sure that workers have training so that they can voice their concerns. And rather than using the format of social auditing, workers are employed and trained by the accord, and they work with trade union leaders to participate in inspections and obtain copies of inspection reports made available in the local language. And they're also able to get in contact with accord case workers to intervene where management refuse local union participation in inspections. So the accord mandates that the complaint system, which maintains confidentiality, is implemented, which ensures that workers can raise health and safety concerns in a timely manner. And regarding remediation, if a factory closes or any corrective action is being taken, the accord provides for workers to receive compensation beyond the amount set out in domestic legislation, and the workers play a role in negotiating. And disputes are settled via binding arbitration enforceable in the home country of the company against whom proceedings were brought. So in conclusion, what is the way forward? We need to ensure that workers are continuously involved in the protection of their own rights via participation, training, a complaints mechanism, and the right to remediation. For example, severance pay in the event of job loss, which occurred on a large scale during the pandemic. And, I think, of course, that was never really fully recouped for workers. So the model of legislation to best achieve this, mandatory human rights due diligence, although it's not a perfect model, it is the one that most countries are gravitating towards, even Canada. So the key is including a duty to consult with stakeholders like trade unions and worker representative organizations when developing and implementing due diligence processes. And rather than relying on social audits, companies must conduct an ongoing consultation with workers and their representatives when developing and implementing these due diligence procedures, including remediation. Thank you.